Hi, this podcast is on retroactive versus prospective legislation in the California state legislature. In most instances, as a general rule, legislation applies only prospectively, meaning that the law that's been enacted takes effect going forward, not retroactively. Nonetheless, there are times when the legislature desires a statute to be applied retroactively. Sometimes they even specify a prospective or retroactive application date. For example, during the COVID-19 pandemic, bill language was often used and intended to apply retroactively. For example, the following is from a bill. The requirement to provide COVID-19 supplemental paid sick leave as set forth in this section shall take effect 10 days after the date of enactment, at which time the requirements shall apply retroactively to January 1, 2021. Sometimes the legislature does so by stating its intent that a court apply a bill retroactively. For example, a recent bill said, "It is the intent of the legislature that a court interpreting this section as amended by the act adding this subdivision should do so in a manner consistent with the interpretation of this section as it read prior to January 1, 2013. Sometimes the legislature intends a bill not to apply retroactively. So for example, we found this language: the amendments to this section made by Senate Bill 284 of the 2021-22 regular session shall not apply retroactively to injuries occurring before January 1, 2022. Then there is specific language as to when it may be applied prospectively. In that same bill, we found for individuals newly covered by this section shall only apply to injuries occurring on or after January 1, 2022. There are other instances where, for example, the legislature intended retroactive application and to actually overturn a court decision. Here we found language that said, notwithstanding any other provision of law, any injunction or judgment in effect as of the effective date of this subdivision, suspending or otherwise affecting enrollment shall be unenforceable, and that the amendments made to this section by Senate Bill 118 of the 2021-22 regular session shall apply retroactively to any decision related to enrollment or changes in enrollment made before the effective date of this bill. And then lastly is an example of language of a bill intended for retroactive application and that an earlier court decision be basically overturned by this legislation, where they said the amendments made to this section shall apply retroactively to any decision related before the enacted and effective date of this bill. So in all of these examples I've cited, the legislature either stated an operative date of statutory language, or the legislature expressed its intent as to when the specific statutory language would be applied. In either instance, the courts in the state are going to go through a process by which they determine whether the statutory language will or will not be applied retroactively in the circumstances before them.